me. I'm the chair of the committee. This morning we're looking at the issue of property and management companies. Can I ask my committee colleagues to introduce themselves, please?
Mayor Ellis from Ribble Valley.
I'm Nishaba Khan, I'm the MP for Gillingham and Rainham.
Chris Curtis from Milton Keynes North.
Morning, Andrew Lewin, Welland Hatfield.
Joe Powell, Kensington and Bayswater.
Good morning, Will Forster from Woking.
Lewis Cock and Broxbourne, and I am a leaseholder as well.
Can I ask our guests just to introduce themselves, please? Halima.
Morning, my name is Halima Ali. I'm from Homeowners' Rights Network.
I'm Richard Best. I'm an independent crossbencher in the House of Lords.
I'm Beth Rudolph. I'm Director of Delivery at the Conveyancing Association, co-chair of the Home Buying and Selling Council, and lead on the Digital Property Market Steering Group's Digital Property Information Protocol.
Thank you, and welcome to our committee this morning. I think it's fair to say this is an issue that fills many of us as MPs and probably peers as well inbox in terms of the issue of property management. When they run well, it's fine, and residents and leaseholders have a good service. But I think far too often we are seeing a case where a number of residents and leaseholders are complaining about the level of service they're receiving from their respective property management companies. I just wanted to start off with just quite an opening general question to all of you on the panel in terms of how reasonable do you think management companies' current rate of service and related service charges are? Lord Best.
I go first. Well, they vary enormously is the short answer. There's some really good agents who give a good service, everybody's happy, no complaints to you. And there's some absolute rascals who totally abuse the system, have no qualifications, don't accord to a code of conduct, rip off their customers, and it's an unregulated sector. Hence the working group on regulation of property agents, which I had the honour to chair, which produced a report saying, let's regulate, let's do the job properly.
Beth.
Certainly from the conveyancer's perspective, we only see them when the property is being sold, and there we do see huge problems with the provision of the information in a reasonable time and for a reasonable price. So they delay the transactions by sort of 57 days from when payment has been made for the information that is necessary for the consumer to proceed. Under material information, that information should be obtained by the seller when the property goes on the market for the estate agent to put it on the advert, but trying to get that information blocks it. But also we've recently had the National Trading Standards guidance on material information pulled, which has caused a massive problem because the agents believe that means they don't have to comply with it anymore. We had got up to 70% of them complying with it, but I'm hearing now that those companies that were providing the information and gathering it for the agents are seeing a 70% drop off on that information being obtained. So when you've got a blocker of the delay and the cost in obtaining that information, and we see packs being charged out at £500, and also you've got that blocker that the competitors are saying, we're not going to charge you that, we'll just put it on the market, we'll take any issue that comes out of it, then the information just isn't being provided. Now the difficulty there is that until you're actually got an offer accepted as a consumer, you are interested in the property, it's like property porn, trying to find out all of the information about it. Once you have your offer accepted, loss aversion applies, and at that point anything that comes up is more of a challenge than anything else. It doesn't put you off. And the difficulty there is that then it means that you will proceed even if the service charges are absolutely huge. That said, I've got a colleague who's an estate agent working in Fulham, and he said that people are just not buying leasehold anymore because they're so worried about the service charges. One of them's been on the market for a year, and it's £7,000 service charge is putting people off unless there's a share of freehold.
Halima, anything to add to?
Yeah, so when it comes to estate charges, we actually can't say for certainty that the fees are unreasonable, as there's no transparency in the fees that are being charged. We do have evidence that an average of 45% of the total charge goes to the managing agent in fees, and that doesn't include non-service costs like insurance, risk management, accounting fees and postage stamp, plus any legal fees which may be incurred defending themselves against action by residents. So when residents get frustrated, we are left with around 35% of the total being spent on contractors doing the actual grounds work.
So just on that, so the Landlord and Tenant Act 1985 states that a landlord can only charge service charges only to the extent that they are reasonably occurred. In your view, do you think that some of those charges are reasonably occurred, or are you finding that in some cases the works haven't been even carried out to a reasonable standard?
There's absolutely no standard in what these managing agents are doing. They are not accountable in any sense at all. And they're behaving like cartels on these private estates. If I can just make the point that these charges, they often rise when developers leave the site, often unfinished and at substandard levels. In terms of, if you're asking me how reasonable they are, every time I have to pay my managing agent, I feel angry. I feel like I'm being cheated. And I feel I'm powerless to do anything with my management company because they have a lot of control. They've got a lot of control over my property. And the thing that's not being discussed is the devaluation of our properties. We're focusing on the fees, but we're not looking at the devaluation of what the system is doing because we have these burdens on our properties. So we're really concerned about the two-tiered housing. The current trajectory this government is heading towards will result in my property being devalued, and we will have problems selling our homes in the future. We are really concerned about this at Homeowners' Rights Network, especially for those of us who are trapped. So we know that estates will eventually be adopted, and that's going to put us in a two-tiered housing system. And I also would like to put on record that even the most stringent regulation won't resolve the problems of devaluation, because people simply do not want the stress. They're not buying their homes to become estate managers. The other concerns we have is that there's a further 3 million people who are likely to be trapped by the system on these hollowed out private estates because the government has promised to build 1.5 million homes. And we're saying this constantly. We don't feel the government's taking the right step.
I think it might be worth clarifying that the Regulation of Property Agents Working Group looked at estate agents, lettings agents for private rented property, and managing agents of leasehold property, and we didn't do very much, and I think it was really we should have done, about the homeowners whose common areas are the cause of the problem, the need to have an estate management company. So those estate management companies who don't have really any rights at all, they're a separate bunch. There are at least some structures for leasehold occupiers, but for the estate management company residents, the homeowners who live there, there's really nothing. And that should be brought into the equation. We omitted them because they were different. It wasn't the properties themselves, it was the unadopted common areas that were the reason for the estate management company.
Yeah. If I can just point out, we do have documentary evidence of homes being of lesser value than properties that don't have a burden placed on them.
I think we'll come on to that. One of the other things, earlier this year there was a debate in Westminster Hall on the issue of residential management companies, and Minister responding, Matthew Pennycook, outlined that for managing agents that have faced poor issues, it said poor service at the hands abused at the hands of unscrupulous managing agents, as well as limited to no transparency about how the charges are spent, onerous restrictions placed on title deeds of the properties, and a general lack of control over how their estate is managed. Lord Best, you alluded to the issues around regulation in this area. In your view, do you feel that this has been too slow, and would this address some of the issues being faced now?
It's been incredibly slow. It was 2018 that we delivered our report. Government was then said it was keen on the idea of regulation and asked us to look at how you would do it. That's six years plus. It's been a constant one of those when parliamentary time allows, soon, shortly, in due course. We've had everything over the years. It's just never been a priority. And in the meanwhile, people get ripped off. I could add to your list, there are commissions on insurance of 65%, an add-on of 65% of the cost of insurance for the work of the agent, which might have taken half an hour. There are the cost of permissions. If you want to change your front door as a leaseholder, you have to pay for that permission to be granted. The list is very, very long, and we couldn't possibly write an Act of Parliament that covered everything. What we could do is have a regulator who does cover everything.
Yeah.
And the regulators, the codes are already written, they're already there. We get a lot of kickback on the basis of cost of regulation of property agents, but when you think that to become a member of Property Mark or the Property Institute, it's less than £300, that's how much managing agents are charging for a notice to be receipted. And this notice is just telling them who the new leaseholder is, but they're charging £300 for that. Now that would get you the membership fee for either of those representative bodies. So it's not huge. I'm regulated by the Council for Licensed Conveyancers and the Chartered Institute of Legal Executives. Neither of those cost me £400 a year. No more than £400 a year to be a member of those and to be regulated by them. So it's not a huge cost.
Okay, thank you. Andrew.
Thank you, Chair. Look, so buying your first home in particular should be a moment of such great excitement for people. Often they've waited 10 or 15 years or even longer to save to be able to do it. But Beth, as you've already touched upon, that we all hear so many stories of solicitors not providing that vital information to prospective homeowners. You've talked about blockers and the cost of the packs. I think my key question is, do you think this in particular needs more regulation? If you don't mind, Beth, we'll start with you, but interested in the whole panel.
Yeah, just to be clear, it's not that the solicitors don't tell the buyers. We do. We send them lots of reports, pages and pages. But by then, they're committed to buying the property. They've worked out where their sofa's going, where the kids are going to school. So what the law says is that they should be provided that information when they're thinking about viewing the property. And that is what is key, because at that point, they then can assess the affordability. The difficulty is that a lot of this information is held by the lease administrator or the managed freehold administrator. And they don't provide that information in time for it to go on the adverts. Also, we're not getting any enforcement of estate agents providing that. So they're supposed to do that since 2008. I went on ChatGPT this morning to find out what the average fine was. There's nothing. Even ChatGPT can't find it. There's no indication of how much the fining is. So there's been no enforcement there. The other issue we have is that any enforcement that is there through the law is not beneficial to the consumer. You think if you don't have an EPC, then the property shouldn't be let. Well, if it hasn't got an EPC, the only thing as you as a tenant can do is complain. Well, you don't get any benefit from that complaint. Same with getting your deposit protected. The only thing there, you'll get your deposit back. The only other thing for houses in multiple occupation is that a Section 21 notice can't be served. But what difference does that make? This isn't providing the safety that we need. Until we get regulation, it isn't going to deliver it. And until we take it out of the public purse and put it into the regulated industry, then there's no cost available to enforce these.
Beth, just you quickly on regulation. Are there other countries that do this well that we can take inspiration from?
Yeah, when you look at the strata system in Australia, and we've all looked at Norway and the regulation that they have there, these do improve the process.
Lewis. Sorry, go on, Andrew.
No, you go, Lewis.
I just wanted to come in there, Beth, just to ask about what information do conveyancing tell people when they're going to buy one of these properties that's a leaseholder that's got service charge, and what information do you provide to them, and how well do you point out the potential charges and all of the rest of it to buyers at all?
Yeah, so when I was in practice, I would get in the contract pack from the seller solicitor. I'd then do a report to my client outlining all of the key things. Then when I got in the local search result, I would report to them and also highlight to them any difference between the information in the search report and the information in the lease report and the contract report. And then I'd get in the information on the seller's TA6 form, and I'd go through that, and there's also a TA7 as well to deal with the leasehold, and I'd go through that and report to the client on it. So you imagine how much this client was getting, and at the end of that they had to decide whether they wanted to go ahead. Now, by the time we got to that stage, they've already got their mortgage underway, they've paid all that money, and they're committed to buying that house emotionally. The reality is all of that information should have been provided when the property went on the market, because that is when they can consume it. Now, under the material information required under the Digital Markets Competition and Consumers Act, that information should be provided on the advert for the property, and that way people can consume it in a way that they understand it.
And is that happening on every occasion and
it's not
every
happening at
sale?
all. It's not being enforced because agents are not regulated, and so it doesn't happen. As I said, ChatGPT couldn't even find a fine that had been made because somebody hadn't done it.
But I think conveyancing is part of the problem. I don't think you guys are as transparent as that. I don't think you guys in your association will tell people what they need to know when they're buying the property, because I can understand that a few people might not know, but I will have whole estates write to me that have gone through multiple different solicitors and conveyancing and what have you, and they will all tell me when they went through that process, the solicitor or the conveyancing did not point out these were the service charges, this is how much it could go up, and all of the rest of it. So I think I think sadly you are part of the problem with this, because you're not being very transparent when people are buying the properties.
I think the problem is that it's hidden in plain sight. We provide all of the information to them, but they're so swamped with information at that point because they've got the mortgage going on, they've got all the removals to organise, that they don't actually consume it. Now, I did look to see if there were any complaints to the legal ombudsman on this and what sort of level of complaint it was, and I couldn't find a huge number of complaints. So if all of these people are finding that they haven't been given that information, they do have the regulator to complain to and the legal ombudsman, and we'd see that in the trade press, but we're not seeing it.
We did have a solution in our working group to this, which was standardised documentation. So everybody gets a very clearly set out statement. How many people who buy know exactly whether there's a sinking fund that has been storing up money, or whether suddenly they're going to be lumbered with a huge bill? They don't even know how much is left on the lease. People, they may have been sent it, they haven't read it, they've seen that the service charge doesn't look too bad, and they haven't a clue what it pays for, what it doesn't pay for, what's going to happen tomorrow. Yeah. So we went for standardised documentation, standardised accounting that sets it out and it gives everybody the same information at the beginning.
Yeah. Andrew, back
just
to you.
Briefly, thank you, Chair. Perhaps one for you, Halima, because really important debate about what people are aware of at the point at which you buy your home, but there is also far too many stories of people believing it's affordable then, but 5 years on you've had a series of increase in prices that are significantly above inflation, and now it's not possible for any organisation, I don't think, to tell you with certainty what costs are going to be. But you spoke earlier of people feeling trapped, and I've certainly heard similar stories, so I'm interested in your view and anyone else on the panel about how you can say to people, look, there is a reasonable likelihood of costs rising by X amount, and you need to be aware of that at the start of the process.
Yeah, so nothing like that is explained at all at the point of sale. All what our members are reporting, and even from my own personal experience, we were just told that is just to keep the estate tidy, just to cut a bit of grass. So all the other liabilities that come by living on a private estate, the fact that we're paying to maintain public open spaces, that was not made clear to us. We weren't made aware that this is going to be tied to our properties as well, these burdens, which is so upsetting. And I just specifically point this particular part out. I've got members who have come to me saying, I've spent £300,000 on my property just to become aware that can be repossessed by the managing company. And in terms of average, what you're saying about costs, starting off small and then going up, we've got a database of 988 developments, including at least 217,000 households. Annual fees, they range from around £100 to £1,000, with the average being around £300. So there's a huge variation and there's sudden increases.
Per annum or per month?
Per annum.
Okay.
And we're also finding that very small developments are often paying more. So if I talk about my own private estate, you know, we're paying to, our estate is coughing up around £25,000 to have the grass cut off of a field that's half the size of a football pitch. And that's per annum.
Thank you.
When we were working with the working group for Lord Best, one of the things that was identified was that most of the agents would have an estate management plan that was 5 years, so that they would know what the payments would be for those 5 years, and that's why, you know, the sinking funds were set at the sinking funds for those longer term expenses as well. So I think it would be totally reasonable to expect that there should be an estate management plan set out for 5 years.
Yeah, absolutely. Be part of the standard documentation that we have.
You suggested that.
Yeah. Standard documents, so everyone knows where they stand, including showing the plan. When is the lift going to have to be replaced? Because it's going to cost $55,000. It's in 4 years' time, I'm afraid, and this is what it's going to cost. It needs to be set out at the beginning. Nobody ever understands what it is they're letting themselves in for.
Thank you. Well,
So I want to focus a bit on reasonable charges, as we've already started to talk about. But so, Lord Best, you've said some property management companies are rascals. Amelia, you've said some operate like a cartel. Have you got examples of best practice of reasonable charges where genuinely that's a reasonable charge, that's what we want to promote? And then have you got some worst case awful examples where actually those companies are ripping people off? The £24,000, sorry, for half a football pitch cutting is disgraceful, is a really good example. But can you give the committee some really good examples and awful examples of how reasonable is interpreted by these companies?
Halima has got some good examples.
I mean, I've not come across any reasonable examples in these 15 years that I've been trapped in this situation, but I can pinpoint out what we're dealing with, and I've written it down.
Just to interrupt you, Halima, you say trapped. Do you feel that if you were receiving a level of service, residents would expect to pay reasonable charges for that? So are you saying that even the fact that, yes, the charges are excessive, are they good services that you're receiving?
Absolutely not.
Okay.
No. And we should not be paying for public open spaces. If that was made clear to us at the point of sale that these are public open spaces where residents do not have an exclusive right, I'm pretty sure people would have refused to buy these properties.
On the cost of the activities, I went out to the Conveyancing Association members to say, can you let me know if there are any particular ones out there, because we did do a survey and we used data out of one of our members, it's one of the largest conveyancers, out of their case management system, and it showed that 98% of notice charges were unreasonable, and what figure we set as reasonable was £100 an hour hourly rate. What we're seeing, and that was back in 2017, what we're seeing now is that First Port and Estates and Management, who are two separate companies on the same leases, are charging £390 for a notice fee. That notice takes 15 minutes to record on their system who the new leaseholder is. They charge an additional £390 for a notice of charge, so to write down who the mortgage company is. And on top of that, Estate and Management, who deal with the ground rent, and they charge as well a similar sort of amount. So if you want unreasonable fees, these are across 98% of the transactions, and those ones, First Port, Estate and Management, are the worst ones that we have.
I just need to really clarify what's going on here. So we are private estate dwellers, and there seems to be a lot of conflation with leaseholders. We are not leaseholders. Leaseholders also have to pay a service charge like us. They don't have access for estate charges to go to the FDT, just like us. When they manage to sort their issues out, if they ever do, they will find themselves stuck in the same situation that we are stuck in. Our issues are related to do with land and property, while their issues are related to do with tenure. And this conflation is causing a lot of confusion with how we're being looked at.
Yeah. Let's bring in Joe quickly, then I'll come to
Just a
Lord
quick
Best.
follow-up question, Halima. If the state remains unadopted, would you support extending the right to manage to those, roads or unadopted parts? Would that be helpful?
So we recognise that there's two types of, there's two types of estates. So there's estates with public open spaces, and there's smaller estates where there's no public right to access and there's no public spaces. And some residents have come to us and they've said they'd like to keep it that for smaller estates. They'd like to continue to keep it managed. They'd like to keep it private, possibly to do with parking issues, and we think that's reasonable. But in bigger estates, we would prefer that is adopted by the local authority.
Best.
Well, we had a couple of ways in which one could improve practice. One would be for the regulator to issue a lot of advice and a lot of norms. The norm is £100 an hour, not 390. And where people are selecting their own managing agents, they can see what the norm is, what good practice looks like, and can compare what they're getting with what the regulator says they should be getting. The other is that we would have codes of practice that determine your behaviour. One overarching code about the good principles of transparency and honesty and so on, but then a detailed one for letting agents, a detailed one for estate agents, detailed one for managing agents of leasehold. So codes of practice would set out the norms of good behaviour, what good behaviour looks like.
And the reality is that actually the delivery of the enforcement of that regulation is much more efficient. When you look at the first tier tribunal and it's completely overwhelmed, it takes about 18 months for a case to be heard. With the regulators, though, we're looking 3 to 4 months for the Solicitors Regulatory Authority. If they get a complaint, it's far less for the Legal Ombudsman as well. And sometimes it's just a phone call from the Council of Licensed Conveyancers to find out what's gone on and why. So that private regulation makes a huge difference.
Thank you. So I think we all agree, probably in the room, that we need to regulate the system. The fact that we as a country have allowed a Wild West to operate on property management companies, when customers can't pick and choose businesses, it's particularly unfair. Can I ask, particularly Lord Best, but I'd welcome other thoughts as well, why do you think we have allowed this system to develop unregulated?
There's a lot of vested interest, and people have done very well out of a system that's very confusing, and mis-selling is common practice, not telling people all the full truth about what they're taking on when they buy. This is gradually developed, and it needs to be stopped. We need to get on top of this. We've got the common hold and freehold, the common hold and leasehold reform bill coming down the track. This is a chance to get in there and have the legislation that we need, the framework that we need.
Can I just point out the sheer abuse that's taking place in private estates is astounding and is a massive headache for residents. Many of our supporters, they say that they're being bullied and abused by managing agents like First Part, like Greenbelt, like Anthem Management, and many more.
Well, we can put some of those questions
defrauded.
to some of the managing agents later, Halima.
Okay.
Thank you. Nishaba.
Thank you, Chair. So I'm sure others have had this too, but my inbox has been inundated with queries around disputes over service charges, particularly with leaseholders. I'd be really interested to hear from the panel what you think about the transparency that exists over the current fees and related charges that are there, and how easy it is for leaseholders to be able to actually resolve the disputes they have around these fees and charges, if there are those.
You go first.
I can't speak about leaseholders because I'm not an expert in that area, but for us, there's absolutely no transparency at all. I've been trying with my managing agent to get them to sit down and talk to me for 10 years. I've even visited their head office. I've spoken to the managing director myself. And it just doesn't go anywhere. Once we try to challenge them, we're just being threatened with debt collection and other arbitrary fees that are being applied to our account. And that just sets things off. It upsets people. And some people start to withhold payment because they don't want to pay for something when there's no transparency about what they're paying for.
Okay, thank you.
At the end of the day, we pass all these laws and there's all kinds of protections supposedly in place, and you can go to the first tier tribunal, but without proper enforcement of the legislation, without an agency that is there just exclusively to enforce what is the law, things don't happen. This is why a regulator, and actually having a regulator, is really important. I have an anxiety that the Commonhold and Freehold Reform Bill, let's get the name right, is going to have some good extra rights and will enable people to do some of the things that we're talking about and require qualifications, might even say there should be a code of conduct, but not go the whole hog and have a regulator. And we need that to enforce the measures that we're all so keen on. Don't leave it to the tribunal, don't leave it to the legal ombudsman, don't leave it to anybody else. Have an agency that's there to enforce, to license the agents.
Can I just add to what Lord Best says here about the LAFRA? So it doesn't implement any of the recommendations that Lord Best has recommended. It adds more work for the FTT by adding in estate charges, but there is no other enforcement of any voluntary industry code. So putting a code of practice into statute is very inflexible and costly to enforce. So it's actually costing more money. It would be in every consumer's interest for an independent regulator to do most of the enforcement. So we are in agreement with Lord Best's report. We do agree that there has to be some regulation as opposed to none right now with the sheer abuse taking place. What we are saying as Hornets is that we are happy with regulation, especially when it comes to large estates, but only if it has to be a stepping stone to adoption. And we're asking government to start communicating with local councils to find a way to get us out of this situation.
Michelle, I'll come back to you.
I think I just wanted to unpick that a little bit further. So obviously we do have the Leasehold and Freehold Reform Acts coming forward, and I appreciate the calls for regulators, which I think is really helpful to understand. But prior to that, is there anything else that we need to be building into this system? Because of course that gets to the stage where you've reached a point where there is no further place that you can go. At this point, do you feel that there is enough of a process that exists that enables people to have a fair option when it comes to dealing with fees and charges?
No, so we need a regulation with teeth that's going to actually hold these managing agents to account. Currently that's not happening, and we're saying that it doesn't make sense to give us the same rights as leaseholders when it's not working for leaseholders already.
Can I just suggest, what we need to happen is for, whether it's a estate management, whether it's letting a leasehold, is that we need to give the unit holders the opportunity to control their destiny and their homes with the public spaces and any shared amenities. We did a survey of common holders. There's not a lot of them, and those that responded, 78% were happy, 88% were happy with the amount they paid. When you look at the Property Mark survey on leasehold, 94% of leaseholders regret buying a leasehold. Now, we're listening here what Halima has said, all of it is a nightmare for them. Yet, when it came to common hold, we still have disputes. 22% had an experience of a dispute with common hold, but the good news is that 75% were happy with the resolution of that dispute. So the common hold regulations have it all set out. It even says that the Commonhold Association doesn't have to enforce an issue if they think it would be more harmonious to the estate not to worry about it. So they don't have to take everything through, only the things that are causing issues to the majority. And wouldn't it be nice to have 78% of leaseholders in estate managed properties to be happy?
It's a shocking figure, 94%.
Isn't it?
Good, thank you. Just coming on back to the leasehold and freehold reform, obviously one of the areas is around the right to manage for leaseholders. Do you think that the reforms outlined will address this?
Well, we've got Commonhold becoming a reality. Although the survey showed Commonhold was doing well, there's only a piffling number of Commonhold
There were 170 when we surveyed them.
Yeah, this is not big time. But what we know from right to manage companies and from resident management companies both, we know that when people are in charge themselves, can take their own decisions, things go better. They don't go perfectly though. And Commonhold, a lesson from the past is that if anything can go wrong, it will go wrong. And you need to know in advance the things that can go wrong and build into the new Commonhold system prevention and protection from those many things that will definitely go wrong. Like the residents deciding, well, we don't think we need a sinking fund. We're not going to be here in 15 years when the roof needs fixing or whatever. You've got to have a sinking fund. This is not going to be optional. So we need to build in the protections into the Commonhold structure. Just abandoning people to do their own thing isn't going to work. And lots of people will be intimidated at the idea of becoming directors of a company. Behind all of this, though, you need a regulator, because Commonhold associations, as they're going to be called, Commonhold associations, need managing, just like anything else. Yeah. And that needs the regulation of those managers, just as it does for existing schemes.
But don't you think that if the leaseholders or the common holders are the ones choosing who is going to manage their estate, then those managing agents will be moving more towards customer satisfaction and reviews and making sure that everybody thinks they're great, rather than trying to cut costs through the back door. And First Port paid out £11 million of dividends last year. So there is money being made there that could be reinvested back into those estates to deliver better to the unit holders.
Would you not agree, though, that for many of the residents, as Halima's outlined, a number of them just want relevant redress to the issues they're facing, and at the moment, by working with the managing agent, they're not getting that? Do you think that a form of, if we move down, moving down to managing, right to manage for freeholders would address some of this?
It'd give us some form of control as an interim. I mean, just looking at my notes. So the impact, it will be of enormous benefit. We do agree there, because it will give us control and accountability over costs and value for money. It would not, however, remove the onerous liabilities for unremedied defects in the substandard infrastructure, and some residents would have to carry the burden of an unpaid part-time job as directors. And our point is clear. People are not buying their homes to become estate managers. Yeah. There's also the issue with SUDs. These are infrastructures that benefit the whole community in terms of flood defence, but private estate dwellers are having to pay to maintain that. That is also incredibly unfair. Councils need to manage these as part of their local flood defences, and flood defence obligations, and private residents should not be paying for this.
I'm going to move on. Maya.
Thank you. So just building on the conversation around the Reform Act, the government's obviously announced upcoming consultations in a number of areas within this, so service charges, legal costs and consumer protection. I'm interested just what issues you think should be most focused on within those consultations to make sure everything's covered.
We are speaking with the civil service team, and we're trying to shape it. Like we're advising them not what people are after. It should just it should cover stuff like the reasonable of fees, how it's, it needs to establish how people are being affected, and how these remedies would help. Sorry.
Not better.
Well, the Law Commission looked at all of the things that can go wrong and all the things that might be put into. They had 121 recommendations, and government broadly has accepted nearly all of them. We need a proper Act of Parliament that covers the waterfront. It's standardising a lot of stuff so that people aren't reinventing the wheel and doing their own thing separately all over the country. Standardised practice, use of agents, and therefore the need for a regulator behind those agents. We mustn't abandon common hold people and think that just because they're now in control themselves, that's the end of the story. Building safety, for example, high-rise buildings, it's a really onerous task that the managing agents have got to perform. We want really good people doing it, and you can't expect residents to comply with all of the regulations on building safety. They need good agents, and that takes us to there being a regulator to enforce them being good agents.
Anything else to add on those specific areas?
No, we'd just specifically support the regulation of property agents for all the reasons said, but also the creation of reasonable fees. As I said, we based our calculations on £100 now, which works out to be $160,000 a year once you push out that hourly rate. So it's not unreasonable, and yet we've got so many things that are being charged out at an unreasonable rate. Even a deed of covenant, which is not required since 1995, are being charged out at £300. We've got precedents to say that even one where one is required, it should only be 80 quid. But actually, there's the law says you don't need one, but people are getting charged for them, and they will pay up because they want to get their title registered, and they can't register it without the deed of covenant because the leasehold restriction that Land Registry put on there to protect that contractual right stops it from being registered. So it just creates an ongoing thing. So we'd want to see that in any consultation.
Lewis, and then I'll bring in Joe to finish off this section.
I just want to go back to something Beth earlier. So I was asking around the conveyancing process and what information you give to the buyer, and you basically said we give them a whole load of information, wash our hands. And
no, we don't wash our hands.
Hang on 1 second, because I'll come to something else in a minute. And you basically say we give it to them all. It's their fault if they don't know where it is. And then you succinctly explained about First Port charging £390 and another company and what have you. So you could be really doing more in that process when someone is buying a property to point out the pitfalls of management companies and estate charges. So why aren't you you've succinctly explained it to us, why aren't you doing that to sellers that want to buy properties that instruct some of your conveyancing people in your association?
Yeah, no, one of those cases, they CPS wanted hundreds and ended up settling for £330, even though the lease entitled them to only £65. So the solicitor had gone back to the managing agent and said, no, your lease says 65, bring your fee down. And the only way they could get anything was getting it down to 330 and agreeing to pay that, because the buyer said, I just want to proceed, I want to get in and move house. So in the end, it's not about us not advising clients. We advise clients, we tell them what it means to them, and we say, what are your instructions? Do you want to proceed? And generally they say yes, because that loss aversion is kicked in, and they've spent all that money on getting surveys and getting their mortgage product fee and the legal fees and all of those things, and they know there are no other properties available to them in the catchment for the school, so they'll just crack on.
With one quick follow-up, you said 94% regret buying leaseholds. Do you think you're doing enough to point out the pitfalls when people buy?
We can only say to them, are you happy for us to exchange contracts? And if they tell us to exchange contracts, that's what we have to do. We're regulated, and our regulator ensures that we act in the best interest of our client. If our client says to us, I know it's not in my best interest, but I still want to proceed, we have to do that.
I think we're going to come on to swiftly on to regulation now.
So, Lord Betsy, you mentioned a couple of things already where you might have added to your report, as you said, over 6 years ago. Could you just outline, are there any other things that if you were redoing your report today, you would now include?
I think it's stood the test of time pretty well. We had the backing then, and we still get the backing, and we get the backing from the Conveyancing Association, but we get the RICS, Property Mark, the Property Institute, who you're going to hear from later, the Property Ombudsman, the people that provide training and CPD, all this lot. Everybody has stayed firm throughout this 6-year break. No one has reneged on the agreement that this is what is top of the list of changes that we need. I wouldn't say I wouldn't change a word, because we'd certainly do more on estate management companies, but it's a pretty good read still if anyone has the time.
And how
online.
And with this relatively new government, have you met with ministers to discuss your report findings? Are you confident they'll be taken forward?
I have. I've met with Matthew Pennycook, and he's been very sympathetic and says that he's very keen to professionalise the sector, and I should be patient and wait for this bill to come through. And
we're all patiently waiting, Lord Best.
My final question is, several of you have referred to some other changes in the last 6 years to, things like the Building Safety Act, Awab's law, obviously coming into force in October. How do you expect the new regulation of managing agents to interact with those other changes that have been made to housing sector regulations more broadly?
Yeah, well, we've also had the boosting of the social housing regulator and the ombudsman service for housing associations, and the requirement for qualifications, which has come through for the housing associations but not for the private sector. You'd think we might put the private sector first, people are a bit more exposed. But we've done the social housing sector. There is now a relatively elaborate set of regulatory and ombudsman redress functions already there. We haven't caught up for leaseholders in the private sector, for letting agents, and indeed for managing agents of leasehold property, and indeed estate management companies. So there's catching up to do to be the same as the social sector.
Thank you. I think just going back to when we will see the legislation, you'll recall that in the King's Speech, the government did commit to a